Okay, we're ready to start. Well, good evening, everybody, and welcome to Dare to Ask. My name is Elizabeth Howe, and I am chairing this panel, and I will try to exert some gentle control upon the proceedings. So bear with me. So the topic this evening is international justice failing to achieve social justice? And our panel here of illustrious speakers will speak briefly on this issue from the perspective of their own experience and expertise, designed to inform you, excite you, and encourage debate. And you will discern that there is a read across between all of the presentations. I will introduce them in turn, and after the last speaker, I will open the floor to questions. We are live streaming, so some questions may come online. I'll revert to question etiquette later after the speakers have delivered their presentations. So, the topic is international law failing social justice. Now, our panelists will each explore undoubtedly what this means to them. But the definition of international law is very wide-ranging. It includes hard and soft laws, treaty law, regulatory frameworks, customary law, environmental law, trade law, immigration, conflict, regional laws, etc., etc. It's very, very wide. What about social justice? What does that mean? That involves perhaps notions of human rights, access, participation, equality of economic and political rights, the common good. Or are those definitions, are they accurate? So we'll find out whether my panelists, or whether our panelists agree with that. So to our first speaker, Professor Sir Geoffrey Nice. He's been a barrister since 1971, a Queen's Counsel. 1998 to 2006, he led the prosecution of Slobodan Milosevic, the former president of Serbia, at the ICTY, the International Criminal Tribunal for the former Yugoslavia. Now, he's currently chair of the... Now, forgive my pronunciation. There are lots of ways of pronouncing this. It's Uyghur or Uyghur Tribunal, which was established in September 2020. It's a tribunal based in the UK to investigate China's alleged genocide and crimes against humanity against the Uyghur, Kazakh, and other Turkish Muslim population. He's going to speak to us primarily about the tribunal and what it seeks to achieve. So, Geoffrey.
People's tribunals are collections of citizens who decide issues that governments, international organizations, national and international courts fail to resolve, usually for fear of upsetting a powerful country. That was why the first such tribunal was set up by philosopher Lord Russell in the 1960s into the war crimes committed by the United States of America in the Vietnam War. No one dared to deal with this in a formal way, and no one ever has. The Russell Tribunal, which did deal with them, may have created a precedent for such tribunals, but was certainly not a role model. It was hopelessly biased in composition, all anti-American, left-leaning philosophers and the like. Other tribunals have followed in Europe and elsewhere. I've been involved in 4 tribunals by chance and initially not thinking there was much to them. I learnt from the first 2 concerning events in Iran and Indonesia and set up the 3rd and 4th about events in China. The 4th, the current one, deals, as you've been told, with treatment of the Uyghur and other Muslim groups in northwest China, a vast area known as Xinjiang. The tribunal operates in a way to reflect how authorities of all kinds have not dealt satisfactorily with an issue that happens to have caught public interest and generated public concern. So, its 9 members from a wide range of disciplines and backgrounds are not lawyers, nor human rights specialists, nor China specialists, and they have no particular interest in the Uyghurs, save to the extent that they have, no doubt, an interest in the suffering of all humans who allege persecution. The judgment that will be made in December will make no recommendations. Why? Because it is reasonable to assume that governments, businesses, universities, schools, art establishments that interact with China will discharge their duties responsibly once the judgment is known. On what patronizing basis should we assume otherwise? The end of the previous tribunal, the China Tribunal into forced organ harvesting of prisoners of conscience, which, by the way, means killing them, cutting them open, and selling their internal organs, hearts, livers, kidneys, and things like that on the open market. That reflected precisely this approach, saying that such bodies as I've listed should recognize that their reactions with the People's Republic of China, PRC for short, were, to the extent shown in that judgment, dealings with the criminal state. And the judgment may have been more effective because it did not in any way overreach. All members and senior staff of the tribunal are completely unpaid, and they're not allowed to put any money into the tribunal. 3 of the members have legal backgrounds of different kinds, but will actually act as jurors. All members, as equals, will decide facts and will turn to legal experts for directions on relevant law. Lawyers are servants of the people. It's not the other way round. Rarely a proposition lawyers like to hear. Everything is in public. All the evidence is available on the website, including in due course evidence considered but not actually used or referred to. All hearings are videoed. You can see it all on the website right now. The PRC has been invited to attend and to be involved. It's never responded to these invitations, and the tribunal will take account of all arguments that might favor the PRC that it can conceive of. The PRC and various other countries, including our own, have been asked to provide information to help in the work we are doing. All have refused. Now, in modern trials, inferences may be drawn against individuals for not providing material and not giving answers. The tribunal won't do that. It will draw no adverse inferences from failure to provide help or indeed to provide evidence. And it will apply the strictest test of proof in order not to run any risk of being prejudicial to the PRC. The tribunal's only mandate comes from an activist Uyghur NGO, non-governmental organization. People for whom the unusual may be uncomfortable sometimes ask how we can proceed if initiated by a Uyghur activist organization. A very silly question. Who but such an organization would ever ask anyone to do what has been asked of us? Who but the Jews and Jewish organizations made the sustained efforts since World War II to bring Nazi criminals to book? So by what right, then, does the tribunal act? What right does it have? None. none beyond the right any free citizen has to ask questions alone or with others, to write its conclusions in newspapers, research papers, books, whatever you will, but no special right. So what about duty? In 1948, politicians and lawyers who had lived through one and possibly two world wars of incomprehensible stupidity, wickedness, and cruelty realized that they had to do something to stop human slaughter of other humans. And they drafted something of which I expect many of you will know, the Universal Declaration of Human Rights. And international crimes, as now codified, reflect those universal rights. Who defends and sustains those rights, yours and mine? Universal rights are in fact personal. So therefore must be universal duties. Your right is my duty to sustain. My right is your duty, and none of us can be sure governments will sustain them. Imagine the things being alleged against the PRC being proved against the Netherlands, Belgium, France, Spain, the Republic of Ireland, our immediate neighbours, and our government doing nothing. Would you think you had a duty towards your neighbours? You would, of course. And it is no difference if your neighbouring human is the other side of the globe. To perform these personal duties, you need knowledge. And relevant knowledge is what people's tribunals may sometimes bring.
Thank you very much, Geoffrey, and as I say, contain your questions until the end. So our next panellist to speak is Dr Josipa Saric, to my right here. Dr Josipa Saric is a lecturer in law here at the Kent Law School. She is an interdisciplinary scholar specialising in the areas of feminist approaches to international law and transitional justice, with a focus on transnational women's movements and the relationship between law, gender, and nationalism. Prior to joining Kent Law School, Josipa worked at the Croatian Ministry of Justice and on international capacity building projects in the areas of international criminal law, human rights, and regulatory reform. She is going to speak about an aspect of transformative justice, using laws to achieve change and impact. So thank you.
Thank you. So I'd like to begin by acknowledging that the question that we've been given today, is international law failing to achieve social justice, is quite a large question, a big question. And to acknowledge that international law and social justice can be understood very broadly. So departing from that position, I'd like to start with the idea that social justice for me is, or rather the social justice aims, are closely linked to addressing and subverting pre-existing structural inequalities with the purpose of building a more equal, inclusive, peaceful, just society. So to consider whether international law is aiming to achieve social justice, it can be useful to consider how its rules and principles, institutions and mechanisms are addressing issues of peace and justice. So, for instance, are they challenging or reinforcing pre-existing structural inequalities? Are they taking into consideration the complexities of local contexts? And to consider this question, I want to draw upon my research on transformative reparations for victims of wartime sexual violence in Croatia. So a very specific and local example, which I believe speaks to these broader ideas of international law and social justice. So Reparations are mechanisms of transitional justice, of international law, that aim to implement victims' rights to redress or remedy as a result of violations of international human rights law or international humanitarian law. In 2005, the United Nations General Assembly passed a resolution known as the Basic Principles, in short, setting out the measures and procedures for implementing victims' rights to remedy. This soft law, so it's not binding, encourages states to implement reparations that are victim-oriented and non-discriminatory. It's the first international instrument to confirm the rights of victims and provides this comprehensive definition of the victim and sets out these different forms of reparations, so restitution, financial compensation, rehabilitation, satisfaction, and guarantees of non-repetition. So quite progressive in the sense that it's victim-oriented. And though it is victim-oriented, and this is quite progressive in that sense, it was also criticized for lacking a gender sensitivity. So particularly when it came to the remedy of victims of rape and sexual violence in wartime. So for example, how may it be possible to remedy the harm caused by wartime rape and sexual violence and ensure non-repetition if we consider that sexual violence is part of a continuum of violence against women? So it exists. This violence exists in different forms in everyday life as well. So how to guarantee this non-repetition? A solution was proposed by scholars and activists, and this was subsequently promoted by the United Nations, and this idea of transformative reparations came about. So in 2014, the United Nations Secretary General issued a guidance note on reparations for conflict-related sexual violence that called for reparations to be transformative in design, implementation, and impact. And I believe this initiative by the United Nations is evidence of international law, broadly understood here, aiming to address social justice in a way. So what I want to raise here is this key question of, well, what is meant by this idea of transformative reparations, or transformative? How to design a transformative reparation law, and how does one implement transformative justice and have transformative impact? So one of the ways to look at international law and how it enters the local context is through this idea, well, we have these development programs. So, the UN enters the local context supporting certain development. And in Croatia, the United Nations development program supported the drafting and design of a reparation law for victims of wartime sexual violence. So these were victims of the war that took place in the 1990s as a result of Croatia's Declaration of Independence and the breakup of Yugoslavia. In 2015, the Croatian parliament adopted a law that provides all sexual violence victims of the war a one-off payment, monthly compensation for the rest of their lives, access to legal aid, compulsory and additional health insurance, and regular medical checkups. So a very extensive program of reparations, really addressing all the different areas of lives that victims have been affected by this harm. So if we look at it from a first glance, the law is quite transformative on this individual level. It had addressed the socioeconomic issues, the situation the victims found themselves in, and included them in the process of making this law. So there was also a moment of empowerment for the victims. However, on the collective level, and this is the part that I was quite interested in, the law was struggling to challenge the strong norms that perpetuate gender inequality, and one could argue that perpetuate violence against women. And in my view, it required a closer look at what victim and woman meant in the Croatian context. So this required a deeper analysis, a deeper understanding of what these particular identities mean in the Croatian context. So going back to our question, is international law failing to achieve social justice? I think this case study provides some important lessons. First of all, when seeking transformative change and impact through reparations, so for example, striving to challenge and not reinforce structural inequalities or gender inequality, careful attention needs to be paid to cultural norms and the socio-political context, in addition to ensuring that the reparation process is inclusive. So meaningful participation and consultation should ensure that all women and victims from across the political spectrum are included, but it also requires a close understanding of where the power is located in a particular local context. Only this way is it possible to ensure that the law is aimed to empower and repair the harm suffered by the victims of wartime sexual violence and is not reinforcing the very problem that led to the harm in the first place. Thank you.
Thank you very much. Right, well, food for thought there, eh? So next, Professor Nick Greif, Emeritus Professor of the Kent Law School. He, as well as his many academic distinctions, Nick has also practiced as a barrister. He has an operational background as well at Doughty Street Chambers and was involved in a number of international cases. However, what he's going to talk to you today about is the Airspace Tribunal, which is very interesting, another people's tribunal, something that was devised between himself and Professor Shona Illingworth from the School of Arts. They established it in order to examine the case for and against the recognition of a proposed new human right to live without physical or psychological threat from above. I'm not going to say any more because Nick's going to explain exactly what the tribunal is doing and what it aims to achieve. So over to you, Nick.
Thank you very much, Liz. Good evening, everybody. It's a great pleasure to be back on campus. In March 1954, the United States carried out a thermonuclear weapon test on Bikini Atoll in the Marshall Islands. It was 1,000 times more powerful than the bomb that destroyed Hiroshima. 62 years later, in March 2016, in his opening statement to the International Court of Justice in a case against Pakistan concerning nuclear disarmament obligations, the Marshall Islands co-agent, Tony de Brum, the Marshall Islands ex-foreign minister, recalled how, as a 9-year-old boy, he'd seen children playing in the radioactive dust that had fallen from the skies. They thought it was snow. One of the things the Marshallese people lost that day was the freedom to look up at the sky and not feel threatened. For Shona and me, that was a key catalyst for establishing the Airspace Tribunal in 2018, to examine the case for and against a new human right we're proposing, the right to live without physical or psychological threat from above. We're all increasingly subject to the exploitation of technology in airspace and outer space. The sky and our relationship to it are being transformed by AI, new weapons and surveillance systems, and by pollution and global warming. And competition between states means that this transformation is accelerating and growing in complexity. And the threats are not adequately addressed by international law. As Liz has said, the Airspace Tribunal is a people's tribunal, and it's drawing on a wide range of expertise and, crucially, lived experience. To date, there have been hearings in London, Sydney, Toronto, and Berlin. A further hearing is being planned for next April. And witnesses from around the world are considering this proposed right in the light of their own expertise or lived experience. They're questioned by counsel to the tribunal, who's a colleague at Doughty Street Chambers, Kirsty Brimelow QC, and then by the audience of invited experts and members of the public, the tribunal's judges. At the end of each hearing, after counsel has summed up, members of the audience cast their vote for or against the proposed rights recognition. The proceedings are being filmed and transcribed to contribute to the proposed rights drafting history. Ultimately, we intend to present the UN and national governments with a compelling people-focused proposal, challenging the state-centric way in which international law is usually created. Well, against that background, let me deal briefly with 4 issues. First, do we need this proposed right? It might be argued that what we're proposing is already covered by existing rights, such as the rights to life and health, or the right to respect for private life, especially as private life includes the protection of physical and psychological integrity. But our witnesses have confirmed that there are powerful reasons for standalone recognition. Most notably, and this has made the most significant impact on me personally, we've heard how drones hovering incessantly over war zones cause civilians living there to suffer perpetual anticipatory anxiety as they're reminded of previous strikes. This sustained, intense anxiety results in significant physiological and psychological harm, and children are especially vulnerable. Chillingly, traumatic experiences become encoded in memory and haunt the future, passing down through the generations. Secondly, this proposed right would be a qualified right, not an absolute right. So interference with its enjoyment would be allowed as long as the restriction was prescribed by law and no greater than necessary to achieve a legitimate aim, such as public safety or the prevention of crime. For example, we know that aerial surveillance is not always harmful. 2 witnesses at our London hearing pointed out that it was through satellite imagery that the world learned of the Bosnian genocide. And others have explained how satellites are being used to detect slavery and other human rights abuses, like the ill treatment of the Uyghurs, as well as environmental destruction. Thirdly, it's important for me to emphasize that we're not seeking to prevent states from using armed force in accordance with the UN Charter. But if the freedom to look up and not feel threatened were recognized in human rights law, this could enhance protection under international humanitarian law, IHL. That's the body of law designed to spare civilians and other non-combatants from the effects of hostilities. Let me explain. During armed conflict, human rights law continues to apply alongside international humanitarian law, except by the operation of a formal derogation where such derogation is permitted. Now, while rules of international humanitarian law may be relevant to the interpretation and application of human rights law, the reverse is also true. Rules of human rights law can influence the interpretation and application of international humanitarian law. And that's reflected in Article 21 of the Rome Statute of the International Criminal Court, which states that the court's interpretation and application of the established principles of international humanitarian law, and I quote, must be consistent with internationally recognized human rights, end quote. So crucially, the IHL principle of proportionality, prohibiting attacks which may be expected to cause excessive incidental injury to civilians, would have to be interpreted and applied in the light of the proposed right to live without physical or psychological threat from above. A Chatham House report published in 2018 found that while there's no reason in principle to exclude mental harm from that proportionality assessment, the majority of state practice does not take mental harm into account. It's unclear whether that's because states do not consider that they're legally obliged to take it into account, or because of perceived difficulties in identifying and quantifying the mental harm expected from a particular attack. But by making it clear that mental harm, psychological harm, must be included in that proportionality assessment, recognition of the proposed right would surely incentivize belligerents to develop ways of assessing proportionality in relation to mental harm, especially harm over time. And finally, and very briefly, how should this right be created? Well, it could be recognised by the courts through a dynamic, creative extension of existing rights. But in the interest of certainty and legitimacy, it would be far better to adopt a specific right through the normal treaty-making processes, but with the active involvement of people around the world. And that brings us right back to the Airspace Tribunal and what we hope will be its lasting contribution to the achievement of social justice. Thank you.
Thank you, Nick. Thank you. Right, well, they've done very well. They've kept to time very well so far, so congratulations. You can have your glass of wine at the end. That was the incentive. So, last but not least, so don't let us down, is Professor Diamond Ashiagbor, Professor of Law and Director of Research at Kent Law School here at the University of Kent, an interdisciplinary legal scholar whose work spans labour, equality, regions, European Union and African Union, and law and development and economic sociology of law and the humanities, so a very wide portfolio. Her current research, and I think this is going to punctuate her address to you, examines race and the colonial origins of contemporary labour markets and labour law. And what I think is particularly interesting is that she was among 40 professors to be featured in Phenomenal Women, the first ever photographic exhibition honouring Britain's black female professors. So well done there. And she's going to examine, inter alia, the tension between free enterprise and market control in the context of world trade and global economies. I hope that's a good translation of what you're going to say, with a focus on the massive inequalities between countries that have developed historically through exploitation. So very, very interesting thesis. So over to you, Diamond.
Thank you very much. As Dr Saric has already noted, international law and social justice are both very broad concepts, and there are a number of ways we could answer this question. We could examine climate justice, we could examine economic justice, access to land, access to cultural identity. I want to focus on justice in the context of markets and social rights. And that does relate very much to my recent research on race and labour markets. So what I want to talk about is justice within a country or nation in order to understand the possibility of using international law to achieve economic and social justice between nations, in particular in light of the ongoing injustices due to legacies of colonialism and empire. So my talk will be a bit different in that I'm going to spend a bit more time examining the past in order to understand the past, in order to understand the scale of injustice in the present and how it, and whether it can be remedied. So to begin with, economic inequality within countries and between countries. Orthodox economic thinking, which has dominated global markets since at least the 1970s, posits an opposition between markets on the one hand and regulation on the other, so market versus the state. And the argument here is that economies cannot or should not be politically governed. Instead, perfectly competitive free market economies should be the proper guiding instrument by which people organise their economic lives. So many of you will have heard of the term neoliberalism, which is used to refer to an approach towards economic and social policy that assumes that deregulated markets and markets which are free from state intervention are the most efficient means to run our societies. So that could be labour markets, like markets for labour, for people selling their services, markets for products, as well as markets for health, education, social services. Everything should be marketised. So there is, though, a limit on how, so that would suggest a limit on how much we can use law to intervene to impose social justice within a nation. So the government shouldn't interfere in the market for labour, for example, by setting a minimum wage for labour. In contrast, a more social justice-orientated view would contend that the market system needs to be met by some kind of counter-response because to protect society, to protect people. So law and institutions are necessary to restrain the sort of free operation of markets. Modern economies such as the UK have come to accept to some extent that in order to secure domestic stability, some state intervention is legitimate. So, for example, the welfare state. There are arguments about how much, though. So we see differences between countries which would otherwise be market economies, say differences between the UK, the US, Sweden, on how much to allow for bargaining to achieve higher minimum wages, provision of public utilities such as water on a non-profit basis, so social rights in the national context, social safety nets essentially are justified because they ameliorate the harshness of markets. And in an industrialised country such as the UK, it's important to recognise the role of trade unions. So I'm going to talk about the global north and the global south. Many of you will come across those terms. It's a very, very rough and slightly inaccurate way of dividing the globe. Global north as a proxy, as an alternative way referring to what otherwise known as the first world, global south referring to the third world. And industrialised countries of the global north, such as the UK, have institutionalised the gains of, say, for example, the labour movement in the form of labour standards, welfare states, social safety nets. So you have social justice within the territorial boundaries of a nation state, holding the social fabric together. Now, there is something missing from this story, and I want to think in terms of racial capitalism, so markets economies and the role of race and colonialism in those. My main point for today is what's missing from that story of social justice within a nation state, within the territorial boundaries of one country, is that race and empire, or more specifically colonialism, have always played a part in the ability to trade of a country such as the UK to be economically successful, to alleviate the negative consequences within the territorial boundaries of these open markets for its own citizens. That's because the ability of industrialised countries such as the UK to embed the market through social transfers, welfare state regimes, was made possible in large part because of transfers from what you could call the periphery to the core, the periphery of global economic activity, namely countries of the global south, towards the core, namely countries of the global north, by means of uneven patterns of trade. So many theorists of market economy, theorists of capitalist markets, typically don't acknowledge the ways in which that market development globally was fundamentally dependent on colonial exploitation and appropriation. So the fantastically successful growth of the economies of the United States and the UK in the UK 17th and 18th centuries was to a large part because of its trade and its extraction from other parts of natural resources from other parts of the world. So Caribbean historian, economist Eric Williams, writing in 1944, a book called Capitalism and Slavery, argued that the agricultural plantation system in the Caribbean fueled the Industrial Revolution in the UK through the accumulation of vast fortunes by plantation owners, shipbuilders, merchants connected with the slave trade. Even post-abolition, you had different forms of extraction through indentured labour. And as many scholars from the global south have shown, countries such as the UK were able to appropriate the economic surplus from their colonies to rehome that surplus. And that materially and substantially aided their own industrial transition from the 18th century onwards. So this concept of colonial drain, or drain of wealth, refers to extraction of surplus from the economies of colonies, which made possible, for example, the UK's growing accumulation of capital. And that could take the form of different methods. For example, in India, it took the form of the sovereign right of tax collection. In the West Indies, it took the form of the plantation economy. In Ireland, absentee landlords extracted surplus by means of land rent as well as taxes. So the sheer scale of these transfers is phenomenal. Indian economist Usha Patnaik, drawing on nearly 2 centuries of detailed data on tax and trade, calculates that Britain drained a total of £9.2 trillion from India during the period 1765 to 1938. To put this in context, Britain's 2018 GDP, gross domestic product, was roughly 2.3 trillion. So meaning the scale of the British impoverishment of colonial India was so vast, and accurate reparations of the amount drained would collapse the modern UK economy several times over. Other examples that one can draw from sub-Saharan Africa. So, what can international law do to respond to some of these inequalities and injustices? The legal rules of the international economic order were informed by liberal, open ideas of equality, sort of contractual relations, egalitarianism, but they end up perpetuating the economic hegemony, economic dominance of the global north by failing to address the entrenched economic inequality. So you can have a bargain between two equal parties, but if there's an inequality of the two parties coming to that bargaining table, that agreement ends up entrenching the pre-existing inequality. So here I'm talking about the colonial drain. So the rules of the game of the global economic order arguably exacerbate that colonial drain even now. So what would be needed to remedy this would be a rethinking of the rules. One part would be a rethinking of the rules put in place, in particular at the end of the Second World War. The US and the UK agreed a framework for creation of key international institutions, for example, the International Monetary Fund and the World Bank. 45 countries met at a conference in Bretton Woods in New Hampshire in the US in 1944, and their agreement established these global rules of the game, international trade law and so on. Now, the IMF, the International Monetary Fund, and the World Bank continue to be amongst the most relevant, significant, powerful setters of norms to govern global trade. For example, how much you can sell agricultural products for, whether you can have protectionism to protect your country from products from other countries. One of the criticisms of these two bodies is that relates to the imbalances of their governance structure. So, for example, traditionally, informal agreement between the US and Europe means the World Bank president has always been chosen by an American president, and the president of the International Monetary Fund comes from Europe. The underrepresentation, remedying the underrepresentation of low and middle income countries on these Bretton Woods institutions, boards, is exacerbated by that executive agreement between the US and Europe. And it's a quite opening up, making more transparent that opaque system, replacing it with a merit-based, transparent process would be one small way towards opening up the sort of slightly rigged rules of the international economic order. So to give you just one final point, the most recently appointed president of the World Bank, appointed in April 2019, is David Malpass, US national, ran unopposed because of this gentleman's agreement, nominated by Donald Trump, who had quite seriously considered instead nominating his daughter Ivanka Trump. So I'll just end on that point.
Well, from the frying pan into the fire, I think. Well, there we are. There you have it. Four quite different presentations, but with quite a lot in common, as you've heard. So we now have the opportunity to ask some questions. I know we're meant to finish I think that clock is wrong, isn't it, in 10 minutes. But I think we have got a little bit of latitude to go on a little bit further, so I was told. So I'm going to open it up. Now, question etiquette. Please, there are no microphones to go around, but there is a microphone at the back. So please speak up. I will repeat your question so that we can all hear and understand it. Please keep your questions short. Don't use this as an opportunity to make a statement or give a speech yourself. That's not the purpose of the exercise. We'd like to know who you are and what you are very, very briefly. We don't want a large biography. And you don't need to thank the panellists, because that's going to be done officially. So we don't want a sort of a UN speech of thanking. So has anybody got any burning questions? I've got some questions that I can ask to fill in if necessary, but does anybody want to kick off? At the back there.
I hope my voice is loud enough. My name is Shahid, and I just started as a lecturer here at the law school. And the question is for Professor Diamond, which is, you alluded to the idea of law and economics, and at the end of the day, if we all realize the structural inequalities that exist as they are, and at the end of the day, there's these theoretical presumptions from the law and economics school, and we all know that they're also, while we can recognize the structural inequalities, the law and economics school is still on the rise. So would you say that one path to actually to getting international law closer to social justice is through taking the debate on the dominance of the law and economics school more seriously?
The dominance of what, sorry?
The law and economics school.
The law and economics school. So, oh gosh, I've got to try and summarise that. That's really difficult. So I think that you were talking about the law and economics, and if we realise that there are these structural inequalities, and we recognise them and we acknowledge them, then, how can we remedy them? And that is through the law.
Through actually taking that debate more seriously than just a debate that exists really in scholarly circles and pretty much marginalised.
Okay, so taking it to a more sort of centrist approach to how we take this debate. Diamond, over to you.
Okay, thank you very much, Shad, for that question. I think that's a fantastic question because it really shows how important ideas are. So the power of a certain kind of ideology or the power of one story and one narrative. So law and economics is often run together, law and economics, as is quite dominant way of understanding the world, in contrast to, but it's often, one would say, it's under-socialized in that it doesn't take enough account of the social impact of just focusing on efficiency and economic productivity as a way of governing the world. What I would say is the sort of orthodoxies about how countries get to be modern, successful, economically stable tends to follow a particular quite narrow narrative, sort of linear progression. For example, that, let's say, the continent of Africa's present is Europe's past. So if African nations could mimic the open markets that many European countries had in the sort of Industrial Revolution, then they could also modernize their economies and grow their economies. What is really interesting is those ideas don't come from nowhere. In the 1960s, 1970s, you had vast sort of bodies quasi-independent from the US, say for the Ford Foundation. These are charitable organizations which would fund studentships, scholarships for scholars from the Global South to study in places like Chicago, which is a well-known home of law and economics. So, for example, when I visited the African Union, so the European Union, a lot of its headquarters are in Brussels. The European Union Commission, its headquarters in Brussels. Addis Ababa in Ethiopia is similarly the headquarters of the African Union Commission. So when I visited the African Union Commission to speak to some of their officials, a lot of the economists, some of these brightest brains on the continent from Tunisia to Zimbabwe, had a very interestingly similar story about how their economies should grow, which I thought was really interesting because it's so different from what the leaders and the economists of those countries in Tunisia, Zimbabwe, Ghana would have been arguing in the 60s and 70s immediately after independence. So something's happened, and so that there's been a convergence towards this norm and moving away from that dominant sort of hegemonic way of looking at the world, which even dominates the African Union, would be a start.
There we are. Right. Any other questions? Please.
Yeah, my name is Matthew Pearce and I have a question on the Airspace Tribunal.
Right.
Yeah. I was just wondering to what degree you thought your proposed new right could be used to combat climate change in the future?
Right. Now, just so the question was, in respect to the Airspace Tribunal, to what extent do you think the new right could be used to combat climate change?
That's a very good question, Matthew, and I'm not sure I can do justice to an answer. But I think the beauty of this right that we're proposing, it's a generic right to have the freedom to look up, to gaze up at the sky, and without feeling threatened. And that reads across any context you like to mention, including the environment. I love looking up at the stars on a clear night. With pollution, it's much more difficult to do that. Including light pollution, of course, it's much more difficult to do that. We've lost, through human intervention, I think we've lost the appropriate value of the heavens, the space up there above our heads. ad infinitum. The sky has been of value throughout history, down through generations, across many different cultures. And one thing that is coming through the hearings of the Airspace Tribunal is the need to recalibrate things and to re-establish the appropriate value on the things above on the space above our heads. As for the details, I'm not sure that I can satisfactorily answer, but we have to address pollution. We have to address global warming. We might disagree on how to do that, and that's one of the problems, I think. But one thing I hope we could all agree on is the need to restore that freedom to gaze upwards without feeling threatened by whatever it is that is up there, whether it's a drone or pollution or some other human apparatus.
Thank you. Any other questions? Yes, in the middle here.
Hi, my name is Ariana. I'm a third year law student. I have a question, not to specific person, but across the panel. The machinery of war is heavy with money and investment and power, and it's quite sexy business, sorry for the language. So how can we make peace as sexy? And how can we invest in peace and social justice the way that we are investing and talking about war? Because war is how we define security, is how we can say, well, that's what they tell us. It's not really the case.
So basically, how can we make peace sexy is your question. Well, I always think, you know, after the Second World War, that was meant to be the war to end all wars, wasn't it? And I think something like 142 conflicts since that war. So, Josipa, let's come to you, because it's something that's been in your sights. Certainly, one of the recent conflicts. How can we make peace as something people want to embrace as much as they want to embrace war?
Okay, so it's an evening of big questions. I have no idea where to start, but I suppose one way to start thinking about what to do, how to orient ourselves towards peace, is to ask, what do we mean by peace? And what would peace mean to everyone in our societies? And so, from my perspective, you know, from looking at peace from a feminist perspective, especially when we talk about violence against women, is peace the threat that one can be, you know, that one will experience violence just because we don't have a conflict? Does that determine peace? So in a way, it's acknowledging that war can mean different things, but also peace can mean different things, and starting from the little bits of how do we ensure a peaceful existence, I suppose, in those little moments of life, and then build from there, and what that means for everyone. And, you know, jumping out there with the big idea, maybe that's another tribunal to think about what peace means and what do we want peace to be. I don't know if that does your question justice.
Does anybody else want to come in there?
Well, I don't think I have a very substantial contribution to make, but many conflicts either come into being or continue because it suits big powers to keep information from the people who are likely to suffer. And I think, inspired by the tribunal and the possibility of adding a human right to space, I've long felt that there should actually be a human right to know. And I think if one could devise methods to make it harder for states to keep from participants the truth of what is going on, it might be harder for conflicts to continue. And just to take an example from the Yugoslav conflicts, it's quite clear that the West was determined not to have a Muslim state in the heart of Europe, which is why it abandoned Bosnia and has lied about its contribution to Srebrenica, and will carry on lying, although in your lifetimes I hope you'll eventually discover the truth. That sort of truth, if it had been allowed to emerge, might, I don't know, have made it harder for that particular nasty conflict to continue. And I think you can probably think of some examples, but it's a great question with no clear answer.
Mm-hmm. Well,
I'd like to.
Yes, please.
I think that's a fantastic question, and it immediately made me think about the US military withdrawal from Afghanistan recently. And that, so on the one hand, I mean, I'm sure you're familiar with this as a law student, that you start off with what you want to be intrinsic arguments to justify, let's say, human rights or the right not to be tortured, and you end up sometimes veering towards instrumental arguments. That it's not so much that, of course, it's important not to torture human beings, but actually it's not efficient. It's not an efficient way of protecting people. And I'm thinking about what you said, how can we make peace sexy, is if one could monetize peace in the way that military intervention in the name of nation building was monetized, then that might be a way of doing it, because one sees with the US military withdrawal from Afghanistan, there was huge amount of money investment into the country, but it seemed to come out to the country quite quickly because it was investing in the supposed build of infrastructure, which were often US-based infrastructure countries. We think about withdrawal from Iraq as well, companies like Halliburton. So the kind of military-industrial complex would have to shift to find a way of monetizing peace for that, I think, to work, because at the moment, war and military intervention is what's so effectively monetized.
Yes,
Could
please.
I make a
Please,
very,
Nick, yeah.
very brief contribution here as well? I think one of the things that has emerged from the hearings of the Airspace Tribunal and other meetings that have been held in relation to it is that our proposed right, if it were adopted, would benefit states and not just individuals. Because when you think about it, if hearts and minds are to be one, then people need to feel free. They need to feel that they can gaze upwards without being threatened, without feeling threatened. So in the discussions that we are have had and will continue to have with the defence establishment or national military governmental military experts, legal experts, this is one of the arguments that we are using. You know, this right isn't just there to benefit individuals, but you need to take stock of it too. It can benefit governments too, because at the end of the day, you need hearts and minds with you.
Yes, monetizing peace, that's a thought, isn't it? I was always told that conflicts and wars were often just a question of geography and land grabbing, and I know there's more to it than that, but yes, trying to find a way of making it economically viable to have peace would be a good way forward. So thank you for the question. So I've just got one question I'm dying to ask Geoffrey. Looking worried, good. Which is, I just really wanted to ask you about government support for the Uyghur or the Uyghur Tribunal, and I think you have touched upon it, but has there been any government support for it? I mean, in particular, has there been any UK government support for it, or has there been the opposite? I'd be interested in knowing.
Well, they've given some support for getting visas for witnesses to come to the country. But I have no idea what drove them to do that. They couldn't quite get away without giving us any assistance because they'd been compelled in Parliament in a series of extraordinary debates last year about genocide. They'd been compelled to say that they were going to support us, and so they had to do something. Our Freedom of Information Act requests have so far got nowhere. And I suspect we're going to do our best, but I suspect they will get nowhere. And the British government in particular, Liz, is a very curious animal on the question of genocide, and I don't know if any of you know why. First of all, the British government never wanted the Genocide Convention, didn't sign up for it for another 20 years, like America, 28 years or something. Didn't want it. It's never acknowledged it in reality, because there's a requirement in Article 1 that if genocide's happening, governments have to do something. So they never acknowledge that genocide's happening. And they will do anything they can to avoid there being a clear determination that genocide is happening. So whatever help they may have given us, they're not providing us so far with answers to our requests for information, would suggest that maybe their overall intention is not to help us, but to be seen at the end of the day to say they've done something so that they can't be completely trashed in Parliament. All other countries, I think, have so far not helped, possibly for similar reasons. Governments like to keep these things to themselves. They never really want the people to have the whip hand. That would be democracy, and governments don't really ever agree that democracy is a good thing.
I think we've got a few more minutes, so any other questions? At back there.
Hello, hi. My name is Minghui. I have one question for the panels, especially for Sir Geoffrey. China has been reported as a supporter for Taliban government. I mean, they have quite a relationship going on. Yeah, but internationally, there is not much spotlight on Chinese government. But I mean, like people from China, from Afghanistan, and North Korea, these people. I mean, how could international justice help these people who is suffering from their own government?
So I think, let me just see if I've got it. So I think you were asking about the fact that there's evidence, there's growing evidence that China is being supportive of the Taliban. Is that what you said?
I mean, there is a relationship.
There's a relationship, yes. I think that the Chinese are already at the airport, aren't they? Supportive of the Taliban government. And I think that you were then going on to say what can international law do about that? Yes.
Yes.
Yeah, and particularly that there's not been much of a spotlight upon China and what it is doing and the pressures that it's bringing. Is that about right?
Yes.
Okay, right. But anybody, I think it was you that.
Well, let me be brief so that others can speak. First of all, I don't know whether what may be happening in support of the Taliban is itself right, wrong, or maybe, whether it's criminal, non-criminal, beneficial, or otherwise. So, not much I can say about that. But what I think one can say is that big countries, China, Russia, United States of America, simply cannot be brought to any form of court. It doesn't happen. There are various reasons we could go into it why you can't get to the International Court of Justice, the International Court of Justice or the International Criminal Court, save in the most exceptional circumstances that aren't going to happen. So, with big countries that are beyond the reach of international law at the moment, you can all live in hope that it'll change and that they'll fall into the net, but it won't happen. What you can hope for is that civil society activity of one kind or another and various other mechanisms can have an effect on a bad country, or what we might like to think of as a bad country. And I'll just give you one example. North Korea is again beyond control because it has the People's Republic of China, amongst others, as its supporter. And there was a wonderful report delivered in 2014 by Justice Kirby, responsive actually to a request from the Human Rights Council, And it was a terrific report. Everybody said as much. But of course, it only ever got to the General Assembly. It didn't get to the Security Council, and it would never get any further. But it is quite possible that what's in that report has led to a change and to a softening, to some degree, of the DPRK, North Korea's regime. And so those of us who would like to see change, but recognizing that there are forces that are the moment beyond us, have to think of doing other things that might bring change by throwing lights on problems. But I'm afraid I can't help further than that.
Yes, some persuasive effect at least. Anybody else would like to speak?
Just a quick comment. I think with when we're talking about big countries, even more than normally, we have to keep our eyes on a distant horizon. Change tends not to happen quickly. I think back to apartheid in South Africa. I think back to South Africa's involvement in what was then Southwest Africa, now Namibia. It took years for things to change. But we have to keep pressing, we have to keep hoping and believing that change will come. And drip, drip, drip. Resolutions in the General Assembly, etc. Civil society, really important, really, really, really important. It will all help. I'm quite convinced of that.
Liz, can I just add a very...
Yes, of course,
that,
please do.
the first tribunal I worked on, and I had a bit part, so I was able to be a bit more of an observer, was the Iran Tribunal. Now, Iran, again, is a no-touch country. You can't... It's too dangerous to touch Iran. The report was, or judgment was very persuasive, very definite. And do you know what's happening now? In Sweden, where there is universal jurisdiction, one of the people named in that report as one of the death committee is on trial, undergoing a 6-month trial for the gravest of offences. So things can happen, and you do have to live in hope.
Yes, step by step, I always say, yes, and one shouldn't stop trying. So on that note, and with that message, I'd like to draw this to a close and to thank our panellists and also the questioners for their very clever questions and also for the clever and erudite presentations. Thank you very much.
Yeah, thank you.
Just one last thing.